Hello, I'm Elias Borges. I'm a lawyer and registered patent and trademark agent with over 20 years of experience. This video is a basic introduction into the field of patents. Now, what exactly is a patent? Well, a patent is a government grant giving the patent owner the exclusive rights to the patented invention for a period of 20 years in those countries where a patent has been granted. There are three types of things that can be patented. Firstly, machines can be patented. For example, a jet engine, bottle, shoe. Materials or compositions of matter can also be patented. For example, a new drug, soap, plastic compound, or alloy. Also, in some cases, methods of doing something can also be patented. Usually, these are industrial methods or methods of manufacturing. But theoretically, any useful method can be patented. Examples include methods of hardening steel, manufacturing glass, processing data, and in some cases, even a new business method can be patented. To be patentable, the invention must pass two tests. It must be novel, that is to say new, and it must be inventive. To be novel, the whole of the invention must not have been disclosed to the public. Publicly disclosing an invention will trigger a 1-year limitation period for filing for patent protection, so make sure your invention remains secret until the application is filed. To be inventive, the invention must be more than a simple, obvious improvement over the prior art. Novelty, that is to say newness, is a critical requirement. To be novel, the invention must be new. It must not have been previously on sale or known to the public. Details of the invention must not have been disclosed in a publicly available document. Essentially, at least one feature of the invention must be new. Examples of public disclosures include published articles, websites, brochures, or even a presentation at a trade show. Now, what are obvious improvements? Examples include a simple change in size, a change in number, or substituting a component with another equivalent component, for example, replacing a zipper with Velcro. Substituting a material, example, replacing steel with aluminum, would also be considered an obvious improvement. Now, a public disclosure means different things in different countries. For Canada and the United States, a written disclosure, demonstration, offer for sale, or otherwise making the invention available to the public triggers a 1-year deadline for filing a patent application. Essentially, there is a 12-month grace period for filing. For Japan and Europe, a public written disclosure will result in the loss of patent rights unless an application is filed before the public disclosure. Now let's discuss the patent process. Firstly, the patent application is prepared, usually by a patent agent such as myself. This takes anywhere from a few weeks to 6 months or so in most cases. Then the patent application is filed. Many people will refer to the invention using the term patent pending at this point, after the application is filed. The application then enters the processing stage, which often requires responding to office actions, which we will discuss later. This can take between 6 months to a few years, depending on the facts of the case. The last step in the process is to pay the grant fees after the application has been approved. Now let's talk about the patent application. There are two parts to the application: the specification and the claims. The specification contains the title, detailed description of the invention, and the drawings. The most important part of the application, however, is the claims. The claims define the ownership of the invention. The value of the patent is determined by how broad the claims are. Generally, there is a maximum of 25 claims. Now let's talk about patent prosecution. After the application is filed, the Patent Office will review the application and issue a report if there are issues. Preliminary issues, example drawings, are generally raised within the first few months, while obviousness or novelty issues are generally raised later. There are generally deadlines of between 2 to 6 months to reply to these reports. Amendments to the application can be made in response to these reports, but no new matter can be added to the application. If a patent is to be obtained in several countries, then there are two ways to proceed, either by way of the Paris Convention or by the PCT, which stands for the Patent Cooperation Treaty. Under the Paris Convention, you can file multiple applications in different countries, one at a time, and claim the benefit of an earlier filed application, provided those applications are filed within 1 year of the first filed application. Essentially, the subsequent applications in the other countries are all backdated to the date of the first filed application. Under the PCT route, a special PCT application has to be filed within 1 year of the first application, and then the foreign filings can be delayed by up to 30 months from the date of the first filed application. The PCT route essentially gives you an additional 18 months to file in other countries. Now let's suppose the Patent Office or offices has approved the patent application. What happens next? Well, after all issues have been resolved with the Patent Office, a notice of allowance will be issued. A few final bookkeeping issues may have to be resolved, and an additional fee must be paid. The Patent Office then grants the patent. The patent will last for 20 years from filing date of the application. However, periodic maintenance fees must be paid. Okay, so now you have your patent. How do you enforce it? The first thing to remember is that the patent gives the owner the right to sue anyone who makes the patented invention, sells the patented invention, or uses the patented invention, or otherwise practices the patented invention in the country where the patent was granted. Now let's talk about what you can do to enforce your patent rights. The first step would be to use the term patent pending while the application is still pending before the patent offices. In the event someone is practicing the invention while the application is still pending, it is possible to send a cease and desist letter, preferably from a lawyer, to hopefully scare off or otherwise intimidate would-be patent infringers. It's even possible to expedite the examination of the application and request early publication of the application if infringement is going on. Now, the first step to actual legal enforcement is to first send a cease and desist letter giving the infringer a deadline to either stop infringing or sign a royalty agreement, depending on what result you want. If that does not work, then you follow up by commencing legal action and serving the infringer with a statement of claim. The legal action can ask for both monetary damages and an injunction compelling the infringer to stop practicing the invention. It is possible to expedite the action by attempting to get an interim injunction prohibiting the infringer from practicing the invention until the matter is finally decided by the court. Generally speaking, 90% of all legal actions are settled before trial. Well, that's patents in a nutshell. Of course, there's a lot more to patent law than we have covered here today. If you have questions concerning patents, or if you are interested in obtaining a patent for your invention, then please email me at this email address, or just give me a call. I'm Elias Borges, and thank you for watching this video.